Alrighty, good afternoon, good evening, or whatever time of day it is, my fellow emoluments. We're here to discuss criminal law due process 2.0. What does that mean and where does it come from and why? So let's begin with our sources. Mason's Manual, which is our day-to-day operations. Jefferson's Manual, that's the internal workings of government, the internal workings of a mechanism, big corporation, whatever. Stuff that most average people don't see. The dictionaries, Law Dictionary, Standard Observance Dictionary. Criminal evidence for the law enforcement officer, stuff that cops already should know that this was part of their academy training. This is my particular copy of this book. And of course, American jurisprudence, pleadings and practice forms, annotated. So, restructuring is imminent. Projects sometimes change direction with no notice. The work remains constant. Discharging the known theft is the target. We know that. So, where do we go? Forged in the pages of history lies the answers to every unanswered question you may have about what's going on. First thing we need to know is what is a Congress and why does it exist? Those are our representatives, those people that we appoint. We elect them into public office. In the beginning, it was dominated by merchants, those of us who provide goods and services to the people every day. This became a career of its own as the country, quote unquote, evolved. So your perceptions of Congress, if you look at this from the pages of history, should be that, when you walk into one of the, for example, a storefront, you might see one of your legislators. Well, doesn't doesn't work that way. So, but we're gonna go through that. That proposal was to discuss these, this section here, and where we currently are, convulsions that now shake it to its deepest foundations. That would be our republic. The ministry, finding the brave foes of Britain, though frequently defeated, yet still contending, took up the unfortunate idea of granting them a hasty peace and then subduing her faithful friends. These devoted colonies were judged to be in such a state as to present victorious without bloodshed and the easy emoluments of statutable plunder. There it is. So, moving down just a little bit, that would be right about where, if you can see where my mouse pointer is. Parliament was influenced to adopt the pernicious project. That pernicious project is where we are today. So, let's kind of dig into it. After that, after the dust settled, I guess, as it were, we returned to the market, margin, and capital post-Reconstruction. We left what was called liaisons to report our business to the people. Those reporters became lobbyists over the course of time with their own agendas. So, again, where all that took place, when all that took place, probably before I was born. So, the point is that's where it was. The good news now is even here in the state of Florida, we have anti-lobbying legislation. So if you go to Congress and you see a lobbyist there trying to get in your way, you can ask that person be removed, and the guard must remove them. So know it, accept it, be prepared to potentially deal with it. So who or what is loss prevention? My job is to manage the emoluments of a company, a big corporation, its market advantage, its profit margin, and its capital gains. So now that we know what my job was, we can pretty much get an understanding of my firm understanding of day-to-day operations and internal management. So, having to be the backbone of any big corporation, it's no matter the extreme nature of unconscionability or extreme unfairness. Loss prevention's attitude is more like, I ain't heard no fat lady. You can forget about it. You're not, you don't scare me. It is what it is. So our jurisdiction, as opposed to being in a big company, we are now in the actual out on the land, right? So pick a jurisdiction, pick a state, territory, state of being, whatever you want to call it. Many people have many different definitions of the word state. So general common observance is Maine, New Hampshire, and Vermont, Massachusetts, Rhode Island, Connecticut, Delaware, New York, et cetera, et cetera, et cetera, et cetera. So that said, ours, we have the right under federal jurisdiction under 28 USC 1443. This is the civil rights removal statute, provides a defendant with a right to remove a state court action in two specific and limited circumstances. So either one or both must be present in order for this to work. So this is why I said we're talking about that Fourth, Fifth, and Sixth Amendment, right? Basic Magna Carta due process, which is being denied by the Sharia law. And we're going to get into what that looks like once we discharge their known theft. Because E-Clause LLC is one of those merchants incorporated. Oh, there's where your standing in law comes from. Suits in like kind. Okay. This is what we're talking about. So I said they want to play monopoly corporation with loss prevention. That's not going to end well. So pursuant to a Mason's motion number 40, which is enter when no other provision for entry is made by the rules. This is sort of a catch-all provision for that. Excuse me. So pursuant to section 245, this is the Mason's manual, by the way, submission of point of order to the House. House has sole power of impeachment. This is why we're going to the House of Representatives. By implementation of the interest analysis technique, if you followed me before, you know, and you've watched me go through and go do behind me on the whiteboard and show what the interest analysis technique looks like on the whiteboard. So attached is the judicial opinion of Justice Eisman in Peterson versus Peterson, where he clearly spells out why statutes are not law and the Code Commission has no legislative authority. This opinion concurrently establishes the State Bar Association's repeated trespasses on the Republic as articulated in the first principle of group decision-making provided below. That would be one of those groups that assume powers they do not have. They claim to have this bar card. I can't go to the Secretary of State and verify what pillar of law that sucker is attached. So that seems to me to be a foreign emolument under Article 1, Section 9, Clause 8. Now that we understand what foreign emoluments are, how to identify them, and what pillars of law, hierarchies, and governments are. So let's go down through it, because why? Our target is resolution. In a republic, we seek resolution, not conflict. So resolutions must be consistent with the law. So here's the law. Heretofore, clearly established with proper United States or U.S. constitutional provisions as outlined as follows. No bills of attainder, ex post facto law shall be passed, blah, blah, blah. Article 1, Section 9, Clause 8. Foreign Emoluments Clause. Has no definition in the dictionary, which I'm going to point out very shortly. Also, heretofore established with proper Florida state constitutional provisions outlined as follows. So here's the law. They'll say, oh, statutes are evidence of the law. Well, I can pass gas and provide evidence of the law of nature, but that's not law. Here's the law. So specifically with what we're going to discuss tonight, Article 1, Section 11, imprisonment for debt. So this is going to make bring into extreme clarity, I guess, by the time we get to the end here. So how do we discharge known theft, right? Of all the issues associated with challenging jurisdiction, discharging the known theft is what leads to the execution of your counterclaims through the process of reconciliation. This is what we're here to discuss tonight. So we have to discharge, right, of the caption attainder, right, these fake attainders, these bills of attainder, orders of attainder, called capias, which I'm going to describe. Discharge of captioned attainder is consistent with said provisions of law as follows, right? Under American jurisprudence, pleadings and practice forms 6:322, the allegation of unconstitutionality, grant of special privileges or immunities. Foreign emoluments. They have no standing. Who did that? Well, the only one that could have done that was Congress. So talk about a bad idea. The statute, that said statute is illegal, unconstitutional, and void in that it purports to grant the defendant, the foreign emoluments, irrevocable or uncontrollable grant of special emoluments, privileges, or immunities, contrary to Article 1, Section 9, Clauses 3 and 8 of the U.S. Constitution and Article 1, Sections 5, 10, and 11 of the Florida State Constitution, as I just showed you. That's how it works. Short version. This is the long version of me walking up to the computer system to input my password to discharge known theft when I was on the clock all day long. So if that's what the long version looks like, so be it. So let's talk about some of that stuff that law enforcement is already supposed to know. Criminal evidence for the law enforcement officer. As I said, I went through this training. I have this book evidenced here in this PowerPoint. So the right of discovery in a criminal case. Oh, that's a right. Okay, we're going to claim and exercise that right. A constitutional obligation required the prosecutor to reveal evidence favorable to the defense, or what's referred to as exculpatory evidence. That's those Brady materials, right? Information favorable to the defense in the possession of the prosecution. Material to the defendant's case that must be disclosed to the defense. The term is derived from the case of Brady versus Maryland, 1963. So now that we know what Brady materials are, exculpatory evidence is, and the right of discovery is, now you can start to exercise under for a notice to produce. See the notices PowerPoint. Subpoena ducis tecum, which is a specific document. Prove to me where it says you have the power to do what you're doing, and they never can. So, voluminous records rule. This is an exception to the best evidence rule that permits a summary, chart, or calculation of voluminous records to be presented in the place of the records themselves. This time, this is what you're going to see referred to on a day-to-day basis in the big companies as a statistical analysis. Pie charts, graphs, models, those types of things. Excuse me. Those things evolve from a compilation of gathered data. So the amount of the voluminous record is sometimes gets called into question, especially if you're talking a large project that affects, tens of thousands of people. Well, how many people did you ask? 20. You're going to have to do better than that. So, in other words, your study wasn't in depth enough. So, kind of give you an idea of the application of voluminous record. So it's important to know that. Keeping in mind that some right or property has already been stolen by these foreign emoluments, therefore employing the necessary criminal process to impeach their case is justified and appropriate. So Why, you ask? To know a thing and to be bound to know it are regarded in law as equivalent. So those of us in position of emolument, we're bound to know what the hell those things are. So now we know why the bar members have strategically removed it from jurisprudence to keep it away from the eyes of the court. That's that fraud upon the judicial machinery of the court, as I talked about it in the impeachments video under Bullock, right? So from 1985, I believe. So let's talk about inevitable discovery. This is an exception to the fruit of the poisonous tree doctrine that states that the challenged evidence is admissible if the prosecution can show that the evidence would have been inevitably discovered even in the absence of police illegality. A dead body in a dumpster. Stupid example, but it is what it is. So fruit of the poisonous tree doctrine. So what the fruit of the poisonous tree doctrine is, this is the principle that under the exclusionary rule, not only is illegally obtained evidence inadmissible, but any other information derived from the illegality is also inadmissible. What we mean when we say tainted evidence. I've used multiple examples in multiple videos. I'm not going to go into that now, but it's just to put it, you wouldn't be able to look for a car involved in an accident in somebody's top desk drawer. So if anything that was found in the top desk drawer is unlawful or illegal in some way, guess what? It's under that particular warrant, they lose the whole case, right? They just tainted the entire warrant, the entire process, and the prosecutor just lost his case. So it's one of those things that you're taught in the academy. Don't ever do that. So the interest analysis technique. This is the conflict of laws. This is from 1964, by the way. This is a method of resolving choice of law questions by reviewing a state's laws and the state's interest in enforcing those laws to determine whether that state's laws or those of another state should apply. As we've talked about, Article 1, Section, I believe it was 3 and 26 in Texas law. Section 26 specifically talks about perpetuities and monopolies are contrary to the genius of a free government, right? So, an example of application of that analysis technique in context. A way to apply stare decisis, for example. As ironic, the way bar members do things, this is the reason these are input this way. In Parliament, when we go to the legislature and present a question, it must be presented in the positive and then in the negative. But this is why you see bar members, they usually start in the negative, right? To disparage, right? Tilt the scales of justice in their favor and disparage the defendant. Okay, sounds like a Ninth Amendment trespass to me. Moving on. So in these following precedents, we'll start with the top one. Shar v. Collin and Miller versus U.S. Supreme Court ruling that there can be no sanction or penalty imposed upon one because of this exercise of constitutional rights. In other words, if it is specifically mentioned in the Constitution, right to work, ding, 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 no, can't do that. Where the proceeding is administrative in nature, non-lawyers are authorized to provide legal representation. This was a case from right here in the state of Florida in 1963. They're talking about administrative process and administering this stuff. Fine. Okay. There's our standing in law, been that way since 1963. I don't have to go ask the state Supreme Court. They already made that decision, right? You've heard me say this. I don't have to go to the third pillar to ask the third pillar. They've made the decision, right? Yes or no, and why? Intra vires versus ultra vires. I'm going to cover those in a minute. Murdoch versus Pennsylvania. The court concluded that a right cannot be converted into a privilege, licensed, and as a result have fees attached to it. Period. Can't do it. 1943, by the way. And Shuttlesworth versus City of Birmingham, Alabama further accentuates this. If the state converts a right, liberty, into a privilege, the citizen can ignore the license and fee and engage in the right or liberty with impunity. Don't touch me there, right? So, Jenkins versus McKithern, Picking versus Pennsylvania, Haynes versus Kerner, and many others. There are so many to cite. These are just some of the more common that I've seen used in multiple pleadings. Pro se pleadings are considered without regard to technicality. Why? Because pro se litigants' pleadings are not to be held to the same high standard of perfection as lawyers. I'm sorry, I think that's an arrogant statement. Knowing that statutes, codes, and their ridiculous crap, word salad isn't even law. That's just a way for them to disparage your right again. That's what we're talking about, the work product immunity. I know what work product immunity is, specifically talking about, because we're going to be doing transactional audits, right? So what is transaction immunity? This is immunity from prosecution for any event or transaction described in the compelled testimony. This is this is the broadest form of immunity. All right, so we're going to start from the broadest form and work our way inward, right? So what is loss prevention? Oh, that's right. I'm the corporation's internal parliamentarian. This is how I know how this stuff, by the way. So the political realm, when handling diplomatic contracts, you end up with dealing with foreign immunity, right? There's foreign immunity. So reciprocity in diplomatic relations, it's a dicey thing. It is what it is. You know, you're getting into the areas that are outside the scope of the court. The third pillar can't even look at it. So hence the problem, right? That's probably one of the reasons why the courts are looking at these things of separation of powers, because the only thing they can view is 1, 2, and 3. Pillars 1, pillars 2, pillars 3. Why? Nobody has brought the Foreign Emoluments Clause before the court until I did it. But I had to start through Congress, right? Guys, we've been here before, right? Why do I have to shut my office down and come in here and remind you what you're already supposed to know? So hence the joke of 8th grade civics, you know, no official with an IQ greater than room temperature in Alaska, as the courts put it, which I just still think is hilarious. So let's talk about reconciliation, and which version of reconciliation are we talking about? Because there's multiple versions, by the way, one of which family law does apply. Well, I'm not here to discuss that particular one. I'm not interested in that. Some of you might be. I'm not. So the restoration of harmony between persons or things that had been in conflict, reconciliation between the plaintiff and the defendant, is unlikely, even if the lawsuit settles before trial. So one of the reasons why that's very commonly true is if there's a settlement, that usually involves the word compromise, right? Which is both sides give something, but no side gets everything they want. Hence, that's pretty much the way compromise is supposed to be. But anyway, moving forward. Reconciliation agreement. As you see, I have family law X'd out because that's not what I'm here to discuss. We're here to discuss the reconciliation statement. This is a concept from 1912. Remember post-Reconstruction? This is an accounting or financial statement, in which discrepancies are adjusted. Anybody who's done an inventory reconciliation, pay very close attention because you know what I'm about to talk about. You've seen many reconciliation reports print from your various point of sale or inventory mechanism systems. So this is where we're getting into, nor should the court be deficient in showing justice. So we have to factor out through the dismissal or discharge of the known theft and sort out what exactly was stolen and by who. So this process isn't easy. And that's why I said anybody who's ever done a reconciliation report, you're snickering because you know what I'm talking about. So we're talking about capitalism, right? The post-Reconstruction de jure republic, right? When we went into the market, margin, and capital, but we're still accountable to the people and through our what? Stock market, right? We sold shares of our companies for the average person to invest. That's what the stock market was all about, right? Investments and returns on those investments, depending on the goods, services, and quality, et cetera, et cetera, et cetera, et cetera, right? How that thing got perverted over the course of time, well, foreign emoluments, you mean pulling the same crap they pull throughout every other time in history, pernicious project notwithstanding. So here's the evidence that there's no definition, right? Why does Article 1, Section 9, Clause 8 not have a clear definition in the law dictionary, especially now knowing what the letter of the law states? I see Article 1, Section 6, Clause 2 clearly right there. Where's the Foreign Emoluments Clause? You mean because the foreign emoluments didn't want it defined. They spent great deals of money, stuff they made up, hence the SMU, and literally bought their way into exclusion. The Bible refers to this. The greatest feat the devil ever accomplished was to convince the world that he didn't exist. Perfect example of that in context right here in front of you. So what do emoluments violations look like? Kind of like what? This garbage, perhaps? He has erected a multitude of new offices and sent hither swarms of officers to harass our people and eat out their substance. Oh, this language from the Declaration, by the way. We went through and we finally solved it. What's the object and what's the design? The object is emolumentum, right? That 13th century definition: advantage, profit, gain, and benefit. 4 pillars. Our republic only has 3. Too bad, so sad. So there's your perpetuity. That's what it looks like to model it. How I know what I know was I audited all of those ill-gotten gains. Title A, Title B, Title C, Title 4, A, B, C, D, and E. Many of you are paying closer attention to D and E depending on your involvement. Do you ever wonder where all the money went for A, B, and C? Because there are never any services provided, but there are transactions. I'm just going to leave that right there. So anybody, dads and family court, be like, we'll have our 15 minutes right after court, son. And anybody who's walked out of family court going, what the hell is emolument is that? So looking at Sylvester in this particular example, you know exactly what I'm talking about. I'm not even going to go there. So let's begin the reconciliation. This came from a document. This will be posted. This document in its entirety will be posted in the Patreon site, along with this PowerPoint, so you can know exactly where I found this word here, human capital. There's your pernicious project, human capital. Pay close attention from here on out. The definition of capital in the private sector for us is money or assets invested, right, or available for investment in a business. The total assets of a business, especially those that help generate profits. And of course, number 3, the total amount or value of a corporation's stock or corporate equity. Now that we know what capital is, right? Capital gains. So this is what they've been targeting, right? Our capital, human capital. Well, according to the ideology of a republic, the person of a human being can have no price put on it. It's a maxim of law. Hence the reference of, I believe it was Benjamin Franklin. Basically, the difference between a republic and a democracy. A democracy is 2 wolves and a lamb voting for what's for dinner. A republic is a well-armed lamb objecting to the vote. So you can consider me the well-armed lamb, right? Moving forward. Here's what we're here to talk about. Capias. This is their preferred weapon of choice. This is any various types of writs that require an officer to take a named defendant into custody. A capias is often used when a respondent fails to appear or when an obligor fails to pay child support. I thought we already found that to be unconstitutional back in what? Late 90s, I would say. So hence the getting into the fake precedent that the foreign emoluments, right, and the fake deals that they did and made with each other. You know, you're going to hear a lot about secret societies and all the other crap. But anyway, in so much as the reconciliation statement, we're going after every one of these capias. We need to discharge those. Why? Because every one of these transactions, these become what's called an instrument. This is a written legal document, such as a contract or deed under the Uniform Commercial Code, human trafficking, right? A writing that evidences right to payment. Well, they have no right to payment. They're claiming a right that they don't have. And the known theft, of course, is when I audited that Title IV and found they were stealing 80% of the money that I was sending to the wife and the kids. So I said this, you don't mess with loss prevention and think you're going to come out of this on top. You can forget about it. You'll never be smarter than loss prevention, ever. So where is capias? Where does it come from? Here's one example of that. This is a writ issued against one who is indebted to the crown, commanding the sheriff to arrest the debtor. I didn't know we had kings here. I thought this was a republic. So who the hell died and made these extra foreign emoluments God or king or the crown or whoever they think they are, right? So pay very close attention, third pillar actors, because this is how they're targeting you. In a republic, in context, right? Definition number one. This is a government having a chief of state who is not a monarch. Maybe clarify that one more time. Who is not a monarch. In a government with definition two, a government in which the supreme power is held by the citizens entitled to vote. Oh, yeah, that's right. One of them electors, voters, right? Hence injury by fellow servant. These are various definitions of other types of capias documents that we're going to be looking for as we reconcile. That's the reason they're in this video. I'm not going to go through every one of them except to put them up on the screen. And this way you guys will kind of get an idea, and girls, of exactly what it is we're going to audit, what we're looking for. Some of the key words. Capias, of course, is the first one. And there are various other verbiages of language and different depths of systems that we're going to have to dig into. So these documents, though usually referred to as a capias writ or writ of attachment, right? That's probably 99.6% of what we're going to be discharging. So what the discharge does is this adds what's called a satisfaction. Any debt has to be canceled by a satisfaction or a discharge, right? A discharge is a satisfaction, especially when the document has no standing to exist. As I said, we don't have monarchies. We don't have kings here. Who is this jackwagon, right? Decusius, the person whose legal position is an issue, right? What pillar of law is your oath attached? Who do you think you are, right? So let's see. If we are going to go in and we're going to take back what was stolen, right? That's going to be done through a writ of supervisory control, by the way. Different process. This is how we are gathering evidence. So don't confuse the two. Okay. So a lot of the concepts we're going to be using are similar. We're going to be doing this in writs of supervisory control where we can itemize exactly what we're seizing and exactly why we're seizing it. Pretty much the same as any other reconciliation that every one of you have ever done. You know what I'm talking about. So this is why in our business, these are forms of part numbers. You got anybody who's searched for a part number in context of warehouse or whatever, again, you know exactly what I'm talking about. I don't have to go into all that. So there is a capias clause from 1844. This is the language in a writ authorizing an officer to arrest a person charged with a crime, right? Or to summon a person to answer a civil suit. This capias clause is we're going to take these people before the impeachment board. So this is the clause how we're going to use this, right, to force these people to testify before committee in their impeachment hearing. So just to put this in context, the reason that we're going to even utilize that name is because we have to associate it with the evidence that we gathered. So you might hear me refer to them as we move forward as capias actors. So haven't completely developed an entire mechanism to go along with that. I'm looking forward to assembling a team, and we can put all that stuff together. Pretty much just like any other assembly of upper management. You guys know, you girls know exactly what I'm talking about. We've done this before, right? We can reconcile a pretty quite a bit of real estate in just a few short hours. We're really good at this. So paying attention that what we're going to seize is going back to the capital, right? Those ill-gotten gains. So be prepared to follow a bunch of transactions, supplemental transactions of what was seized, because we have to find a lot of this stuff. And I don't mean just stuff, I mean people that were seized, specifically human capital. Why? And what's the law here? Excuse me. Well, the Emoluments Clause, Article 1, Section 9, Clause 8. And it's the correct article of the 13th Amendment that really makes this work. And why? Is because the language of foreign powers, meaning foreign pillars of law. Nobody's above the law. Watch the Barrett, Justice Barrett hearings. We agree with Justice Barrett that nobody's above the law. This is equal oversight, right? So these actors have been claiming, oh, we have all this immunity. We have immunity. We have a hogwash. Nobody has immunity. No, you don't. So just that's the federal law. So let's get into the state law, Article 1, Sections 10 and Section 11. So Section 10 specifically talks about prohibited laws. What part of no, right? No bills of attainder, right? That also includes orders. Orders of attainder and bills of attainder, those are pretty much the same thing, because they can't write an order without a quote unquote act, right? We have a Congress. We have an act of Congress. Yeah, no, you don't. That's pretended acts of legislation. So we weren't part of that quorum. That stuff doesn't apply to us. Kick rocks. No one shall be imprisoned for debt except in cases of fraud. So this is who's going to jail, right? This is why we need to categorize these actors. So again, just in my preliminary assessments and preliminary reconciliations that I've been working on as base models, that of course we're going to, we're going to have to modify these models as we go. I'm calling them capias actors. So we're going to call them, we may call them that, we may call them something else. So moving forward. So with respect to domestic markets, right, before we go back on the clock, What part of no do Democrats in Congress not understand? Right? I mean, it is what it is. No means no. And here's why we're doing this. One of the reasons why we were able to exercising these following due process, we chose a jurisdiction, pick a lane, right? Was signed off on, and we had the blessing of the court. Granted, standing here in the state of Florida to do just what we're doing, going after these foreign emoluments. We're sick of this. They're just as sick of this as we are. And, it's we have to bring these foreign emoluments before the third pillar after a couple of 100 years to identify them as foreign powers repugnant to the 13th Amendment, right? Foreign pillars of law. This is why we keep playing Ring Around the Rosie. It's these same actors pulling the same crap all over again. So, again, the third pillar didn't do it. The third pillar's been misled by the fourth pillar and the fifth pillar, the negative nexus. So, we've already established ab initio, we've already established ex post facto, and we're working on intra vires versus ultra vires, right? We're going to be utilizing intra vires with strict oversight, which is fine by me because I prefer it that way, right? And of course, many of you, as we do these reconciliation reports, you can expect multiple meetings with House oversight, specifically in finance, and Senate oversight, specifically in judiciary. I hope you got a strong stomach because some of these hearings are going to be brutal. I'm fine with that. And I hope many of you are too. So accept that these are going to be pretty long and drawn out hearings as we're going through and we're explaining why we've ripped, the offices of Dewey, Cheatham, and Howe, et cetera, apart, and how we can clarify those as trespasses and foreign emoluments, and why we're taking that property and returning it to its rightful owner, whatever the property is. So, in Ray, right, in the matter of, this is some of the language you guys and girls are going to need to know. In rem, which is Latin, against a thing. The instrument we already talked about, the capias, right? That's the target. We are amicus counsel. Why? We are licensed. We're licensed professionals. We're doing what we already know. So, and I don't care if you want to put your uniform on for whatever company you work for, or if you just want to put an E-clause shirt on, I don't care what you want. I'm pretty flexible, pretty liberal that way. If you want an E-clause shirt, let me know and I'll make sure you get one. And we're going to have two versions of this, amicus curiae and amicus publici, depending on which state, territory, whatever, state, federal. Are we going in as friend of the court? Are we going in as friend of the public? Depending on who the actors are and to what extent the trespass is going to dictate our standing amicus. So that I hope we work together with Congress during the oversight hearings to establish, are we amicus curiae, are we amicus publici, and why, so we can articulate it to the court. There's been so many of these things that have been overlooked because the attorneys, they just got so deeply entrenched into this crap and nobody ever clarified anything. Oh, we're just going to, oh, no, it's just the way we do it. Oh, it's just the way. No. That's the crap that leads us into oblivion. And anybody who's ever worked loss prevention, you know exactly what I'm talking about. You're probably sitting there rolling your eyes going, yep. So now we're going to get into supplemental jurisdiction. This is where we're headed, right? As we remove the supplemental jurisdiction under the grounds, right? Article 1, Section 9, Clause 8 in the proper 13th Amendment. So we have to establish the grounds. We have to establish, and there's our ancillary jurisdiction, right? Our amicus, right? We're licensed. We already know we're amenable to the people. Thanks for telling us what we already know, right? Moving on. That's why I said this. Oh, we have immunity. Yeah. Wait a minute. What? So, yeah, tell that to the wife. Personal jurisdiction, constitutional elaborations, right? Substantive due process. This is the reason that we want to clarify with Congress, right? establish a quid pro quo, right? Are we amicus publici on behalf of the public, or cure as a friend of the court? And I'd like it if in that relationship, if the court would tag in on that and help us with specific cases, because I think it's going to make them discharging the duties of their offices easier as well. Because there's going to be some of these cases where it's just prosecutions. There's going to be some of these cases going to be pretty extensive property. So I would say where it's the extensive property, if I'm following my history correctly, that's usually as friend of the court, because under substantive due process, when you're talking about ancillary jurisdiction, there's going to be a lot of disbursements. This is why you're going to be prepared to be we're not using trust accounts, right? That's that form of banking, that foreign emoluments practice, right? No. We don't do that here, right? We're using escrow accounting and various other, transactional matrix. This is going to look a lot like an inventory mechanism, right? Except the accounting is going to be more consistent with what many of us already know and can easily articulate to the court. So as we disperse the transactions or the property, right, we can clearly show what went to who, where, when, why, and give them get a receipt, right? It is what it is. So the minimum contact test, not really applicable here, but there may be cases where it might be required, especially with all this COVID crap going. I would certainly hope that we would have decided it's the common cold and we can go back to working, but I digress. The different types, I'm going in personam here. I'm leaving this in there because we're talking about, it specifically mentions a full faith and credit clause, because we're talking about federal law, right? The establishment of federal law. And if we can tie that federal law to a state law, I would prefer for us to do it that way, right? Utilize as much of that state's law as we can, so we can avoid a lot of the interest analysis mechanism, because that's very difficult to go through. So pick your respective state and learn your state's constitution. Pick, what the supreme law and the minimum standard is, so you know what the margins are. Okay, all you need to do is find that mechanism in your state's constitution, right? So we can establish the 2-lane mechanism, right? The quid pro quo and the reciprocity, and open the road. The statutory mechanism. Some of the federal courts may want to still use this, right? And because we know that statutes do not create jurisdiction, they instead are mechanisms to enable federal courts to hear the cases that are already within their original jurisdiction. So understanding that there are going to be cases that we're going to kind of fall into that may already be before the federal court. So we're going to have to be mindful that we don't want to step on anybody's toes or anything that's currently being reviewed. Unless, of course, we have something to offer, that we would just enter a limited appearance and say, oh, by the way, Judge, we found this as we were going. Don't know if it's relevant to you in this case, but it has these actors' names on it. So here you go. The section 143, how these things come before the body, right? This is where we go back to by the book operations. So now that you've assembled, right, we've picked an area, we've assembled, and we've inventoried a crime scene, for lack of a better expression. We've ripped its computer apart, and we've identified all of the capias actors, right? And we now know where we can go and we can say, okay, are these people still incarcerated? If they are, get them out. That's discharging that crap is the thing that gets them out. So I hope that makes sense to you. So expediency of that process would be appreciated. So section 147, right? Committee reports on presenting questions, right? We're going to find that many of these capias cases are going to have multiple folks that are going to be incarcerated, and even more multiple folks that are going to be counter prosecuted, right? violations of the Foreign Emoluments Clause in the 13th Amendment. So you see what I'm saying? There's going to be a whole lot of kind of flip-flop and back and forth. So you're going to have to make sure you're very, you establish a rapport and an open line of communication with your county sheriff, or, you know, whoever's in charge of the jail. And we want to keep these folks in the loop, right? Because we're going to need their help in executing these processes. And also we need to let them know if somebody's targeting them. So if somebody's targeting them, I would think they would want to know it. Same thing with judges. So you're going to find out as we go through the transactions of these capias actors. They'll go through and they'll take their ill-gotten gains. They'll create fake transactions. Here's one I've found in the past. They'll buy a piece of property, put it in the name of a judge, not tell the judge that they did it, and that asset or ownership of land or property will show up as as something that the judge would own, when the judge has no idea what the hell it is or where it came from. This is how these foreign emoluments are disparaging the courts and the judges. So know it, accept it, understand it, be prepared to deal with it. So we'll know more about that, right? Those of you with, former, real estate licensing and brokerage and knowledge in that area, you know exactly what I'm talking about. I'm sure some of you have seen this before. So those of you who have, right, any information that you can bring to the table with how you identified what you identified, so we can input it into the search criteria, would certainly be helpful. So committee procedure less than formal, right? We're going into let the board members, the small committees know, hey, we've got, a series of actors, need to commence impeachment processes on them, and we need to start sending out notices, right? You got to provide notice of the meeting, but we got to have a preliminary meeting to decide what's going to come up at the next meeting, and the meeting before the meeting to decide what the meeting's about. You again, you guys know exactly what I'm talking about. This is why you're snickering and laughing, like, oh yeah, we've done this before. So 633, consideration of measures, right? This is the business of committees can be expedited by the chair preparing a schedule of measures to be heard and given a notice of some time in advance. This is specifically what I was just talking about. Okay, we're going to present them through the parliamentarian or directly to, to the senator or congressman for, are we talking about impeachment? Are we talking about investigation? Do we need an order for investigation? Do we need to pick up orders of investigations that they've already ordered? So I said there's going to be a lot of communication going on there. Again, you guys know what I'm talking about. Will it take the form of a batch program? I don't know. I can't say that just yet because I don't know how long this is going to take. Some states are worse than others. So it's, every state has the corruption problem. Some states are worse than others. So motions to set aside, motions to set special orders. Again, self-explanatory. So what's the special order? Are we ordering somebody be prosecuted? Some of you may want to take part in those. I personally do not. I want to focus on unraveling the crap, because the sooner we unravel this crap, the sooner we can go back to our respective jobs. So think of this in terms of a sort of a grand jury sort of duty, right? So, but anyway, be that as it may, there except that there are going to be many prosecutors that don't even know what the hell we're talking about, and they're going to be just as shocked as you can expect some of the judges to be when you show them, oh, by the way, judge, guess we found out you own swampland in Sahara Forest. Did you know that? So, wait, what? So again, yeah, you'd be surprised the crap that we find. So section 264 continued. where was it? Number 5. A pending question may be made by, a special order for a future time by postponing it and making it a special order for a specific time, such as, like, right? Such a motion is a form of subsidiary motion to postpone, indefinitely, definitely, or indefinitely, and it takes precedent and such. So the this is going to be sections 264, numbers 3 and 5. You might go back and forth with that a little bit. Again, that's going to be sort of one of those informal things that you guys are going to work out between you and your assemblies and your committees, various committees. So, like I said, every reconciliation process is different from region to region. You guys know it as well as I do. So, some guys like beer and pizza, some guys like coffee and donuts. Just it is what it is. Lastly, here on sections, on numbers 6 and 7, you guys need to know what the process is, because the members, right, once we submit this information, we got to make sure that we're following the process, right? And this way it allows it to work. Okay. So if we know, right, and we want to bring something in on a motion to set a special order, right, and you want to associate it with numbers 1 through 7 or whatever, it is what it is. Our limitations, right, on right of legislative bodies to investigate. Section 797, number 3. These are things that we're going to have to watch for. A state legislature, in conducting any investigation, must observe the constitutional provisions relating to the enjoyment of life, liberty, and property. We already are aware that these trespasses have already happened. We're not going to make it worse, right? So that's why I said these are things that we're going to have to be very mindful of. So be very careful. Again, customer service. I'm not going to go any farther than to say customer service and leave it at that. This is the design that we're looking for, right? This is that Title IV, marriage scam, domestic violence contract, garbage, Sharia law garbage, right? This is why these capias orders are not lawful. They're written pursuant to Sharia law. So I don't know. Hey, I'll flip you guys and girls of who's going to tell the wives that they were entered into a domestic violence contract. Not it. So accept it, because I can tell you right now, you think she's pissed now? Wait till she finds out somebody ruined her wedding day by calling it a domestic violence contract. So Obamacare, same problem, or the Affordable Care Act, hogwash. They're going after the endowment funds of the hospitals and the various other medical institutions. That's what they've been doing. So they've been scamming the Social Security mechanism, the retirees, and they're going after the endowment funding of the donors, right, to bleed the equity out. So I said these son of a bitch, they're sick son of a bitches all done, but they're crafty. You got to give them that. So these are the mechanisms that you need to be aware of. There's 2 models for both, profits and benefits. So as we're auditing the systems, we're looking for levels and sub-levels of transactions. You know what I'm talking about. So some of those, we don't know how deep some of these systems go. How many different versions, what type of data, and what type of, search parameters are we going to have to enter? So, are we going to get it all? Probably not. But we're going to get enough of it to certainly make the rest of it fall apart. So here's your litmus test. The bad actors don't want this. And here's the reason why. They want to leave that definition out of the dictionary. They want to be able to continue their bullshit. Guess what? Ain't happening. So this litmus test, this represents not only the word emoluments in context, but also three different systems of government or hierarchies, right? Established, beginning with how many pillars of law they contain. That's why everything, the monarchy and Sharia, are below the line. They have no standing. So there's your deep state. Does that make sense? So, and now that we know them, we can identify them. That's the reason that justice is the exception and not the rule, right? How does it take 17 years to litigate? You can't lie and present false evidence in court. Hence my constant bitching about the Hardwick case. Well, there's your answer. Difference between subsidies and stipends. So if you look at what's above the line, we don't mind paying our representatives to do their job. We don't mind paying our taxes. Hell no, we don't. So this is one of the reasons why we pay taxes, right? So we can go in and do crap like this and get rid of these bad actors, right? I've just never been involved in court proceedings before. We just did it all day, every day. So here's the legislation, right? The purpose of the test was to clearly establish what foreign emoluments in their archaic form actually look like, right? And what I called shit made up, right? Archaic research is not usually my area of expertise, but under the circumstances, the cause, corporation, was justified as my affirmative defense is injury by fellow servant, same as yours. So, believe it or not, our affirmative defense, technically speaking, is our immunity. It's upside down. So, here's the legal maxim that we're going to be predicating this on. The performance of one duty is commonly the excuse for the non-performance of another. Here's what you're going to hear from their customers. I paid offices of Dewey, Cheatham, and Howe $50,000 and they didn't file a piece of paper. Know it, expect it, be prepared. So just like we used to hear it all day, every day, customer would come in, paid X number of dollars for whatever the part or service was, and now it doesn't work. So we have to go through it and diagnose it, right? Calm the customer down. You guys know the drill. They don't have to. So I said customer relations, get ready. It's coming. So this is why I said we now know what foreign emoluments look like, those malicious designs of men that must be thwarted. So little side note from the impeachments video. I don't know if you guys have paid attention to that or not. When you look at the design of the Republic, its design was based off of the isosceles triangle, knowing that there's 60 degrees of separation, degrees of angle, right? Which is also the, what do you call it? Each pillar, right, has equal standing over the other two, right? So this is one of the reasons why we're not going in there like these idiot bar members do. I found this jack wagon. No, we're going to let the numbers prove it. Right? This is how we do what we do. We let the documentation, we let the numbers, we let the process do what it does. This is specifically why I want loss prevention people. So you guys know this. We know this. Public emoluments, you cannot legislate for us in all cases whatsoever. Period. This is conduct of a tyrant. Right? He is suspending our own legislatures and declaring themselves invested with power to legislate for us in all cases whatsoever. These bar members, be prepared. These bar members, guess what else is going to be cool when this is all said and done? We're not going to have to dick around with legal anymore. We're going to be in the loop, right, for handling these legal issues. So, will we spend a lot of time in court? Probably not. So, now that we know how to get rid of this crap. So if I may be so bold as to request any judges who find themselves reviewing this presentation, my hope is that your takeaway here is these three principles moving forward as you discharge the duty of your respective emoluments, right? From your perspective. I know you're looking at them as separation of powers now. So we are all fundamentally principally aware the process of law is a heavy hardship. The execution of the law crowns or rewards the work. These are things we know, right? We've been on the clock doing this salary Chinese overtime, as we joke about it, right? Since we started our jobs. Also understanding that the remedy of law is open to all within or subject to the realm who ask for it. So again, this is a concept that we are employing as we do our respective jobs, right, for our customers. So the precedent, right, when the bar members or anybody is asking you for precedent, please, 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 for the love of God, before you say yes, remember this. A precedent accomplishes nothing if it settles one dispute by raising another. So if you're looking for an excuse to say no, there's one. Blame me. I'm used to it. Trust me. I don't mind playing the bad guy. So thank you for watching, my fellow emoluments. This has been Common Law Due Process 2.0 and specifically talking about reconciliations. So hope you guys enjoyed this, and we will be seeing you soonly.